We'll hear from the plaintiffs.
Mr. Chief Justice, Your Honors, thank you and good afternoon. May it please the court. The commission is here today to argue that the court should prohibit Facebook's merger with CC from going forward, and that it should condemn Facebook's unlawful withholding of its API as an attempt at monopolization. First, I will address the merger between CC and Facebook, and then my co-counsel will address the issues surrounding API. The commission understands that today the court is not merely deciding this one case. It is creating precedent that will govern Masonian antitrust law for years to come.
Well, that depends on the grounds on which we decide, doesn't it?
It does, Your Honor. However, we expect that this merger will be significant enough that it may at least have implications into the future for the law. And because of that, we want to at least be cognizant of that fact when we determine the standard for deciding this case. And in particular—
Forgive me for interrupting at the very beginning, but I'd be grateful if it were possible for the authority to make clear, I speak very generally and very, how shall I say, in kind of shorthand, but we all know that there are in certain fields differences between the United States approach and, for example, the European or the Korean approach. And it would be helpful, I think, if the authority might indicate in the course of its remarks which school, shall we say, it favored. I'm not supporting one or the other, but I hope that in the course of your remarks you will indicate which of the transatlantic, just to make it very simple, the US approach and the European Union approach are significantly different. And it's not that either is wrong or right, but they are different. And it would be nice, and forgive me for interrupting you for such a long time, if you could indicate which regime, shall we say, the authority is favoring and why. Thank you. Sorry to interrupt.
No, of course, Your Honor. Thank you for the question. I will do so presently, and my co-counsel will as well with respect to the API issue. When it comes specifically to the merger, the commission urges the court to follow United States antitrust law. It is one of the most robust and well-developed in the world, and it also favors a consumer welfare standard that maximizes the availability of quality products to consumers throughout the PSNS market. Now,
Counselor?
Yes, Your Honor.
Forgive my interruption. Under U.S. antitrust law, you believe the merger violates both Section 7 and Section 2? That is Section 7 of the Clayton Act and Section 2 of the Sherman Act? Is that correct?
Yes, we do, Your Honor. I will be addressing Section 7 as it pertains to the merger, and my co-counsel will be addressing Section 2 as it pertains to API.
All right, proceed, please.
Thank you, Your Honor. Under Section 7 of the Clayton Act, U.S. law prohibits mergers that are more likely than not to substantially lessen competition. Importantly here, the merger is likely to occasion significant anti-competitive harm to consumers that outweigh any of Facebook's asserted pro-competitive efficiencies. Because of this, the commission urges the court to immediately intervene in this acquisition. Now, even according to the more merger-accommodating United States consumer welfare standard of antitrust law, Facebook's acquisition is anti-competitive and is thus unlawful for 3 reasons.
Excuse me. So you're urging us to use U.S. law, although you say it's more more tolerant?
We do believe that it is more merger-friendly. However, the commission does urge the court to adopt U.S. antitrust law in this instance, but even under that standard, the commission asserts that this merger is clearly unlawful.
So is the idea that if it's unlawful under U.S. law, it's truly unlawful under EU law?
I certainly believe that's the case with respect to the merger. The question of European law will certainly become more relevant when it comes to the API issue. I would prefer to defer to co-counsel when it comes to that issue as it pertains to European law. When I suggest the adoption of U.S. antitrust law, I'm specifically speaking to the Section 7 issue with respect to the merger. Does that answer the court's question, Your Honor?
Yes, thank you.
Thank you, Your Honor.
Counselor,
yes, Your Honor.
forgive my interruption. Is it your position that CC today is competing in the same market as Facebook, or that CC is poised to enter that market?
I would split the difference, Your Honor. I believe that CC is competing in the same market with Facebook, but that it is competing as a nascent competitor that is prepared to break out in a more general capacity to directly challenge Facebook. Does that make sense, Your Honor?
And under Section 7, what level of confidence do you think I need to have that CC will, in fact, arise as a real competitor as opposed to a nascent one to Facebook?
I would suggest nothing more than a preponderance of the evidence, Your Honor. And I think that the evidence that we are prepared to put forth will readily meet that burden. I believe the court had another question.
Well, isn't what you're, this is a very primitive question. CC is tiny. You elegantly call it a nascent competitor, and that means it's tiny, but it might get bigger. I'm not saying it's wrong or right, but isn't the effect of the line you're taking to say Facebook has to grow it at home? Facebook can't make any acquisitions which are lawful, because anything that it acquires bigger than a peanut is going to be called a nascent competitor.
Not necessarily, Your Honor. And the court rightly points to what standard distinguishes this merger from conduct that even the commission would stipulate to being lawful. Now, the commission recognizes that the court's antitrust jurisprudence is also in its nascent stage, and the commission doesn't presume to prescribe a strict line for the court to follow today. Nevertheless, the commission would like to point the court to several factors that it might consider, and this will help, I believe, also in framing the argument that's to come about the anti-competitive harms. First, and I think most significantly, I would describe this as a merger in which the nascent competitor here, CC, has identified a niche aspect of the market that Facebook and all the other firms have thus far failed to innovate. That's the privacy protections that CC offers that no other competitor has been able to match. The second factor here.
We accept, I mean, it's not difficult to say, to look at any competitor, any candidate for a Facebook acquisition and say, it's unique, it's unusual. But surely we have to, I guess I'm really repeating my earlier question. Surely the implication, if Facebook can't take over such a tiny competitor with promise, yes, but still tiny by comparison to Facebook, you're effectively saying, and I'm not saying it's bad or good, but you're effectively prohibiting Facebook from making any promising acquisitions in the future. Now, that might be a perfectly valid line to take, but I'm not convinced that the word nascent solves your difficulties with respect to the legal consequences.
I agree, Your Honor. On its own, it doesn't. CC's targeting of a niche market is but the first factor that we would urge the courts to consider. Beyond that, what we have is a significant potential for competition and growth. As the court rightly points out, CC has the potential to break into the more general social networking services market. Further, it has a significant year after year growth rate. And because of that, poses a serious competitive threat to Facebook, even if it's in its current form. Finally, I think we need to look at Facebook's past practice of acquiring nascent competitors. Yes, Your Honor.
Before we get to the past practices, I want to ask a question.
Yes.
If the theory here is that CC, which is somewhat differentiated as a product, could kind of move in to PSNS, isn't that a problem for you? Because wouldn't it capture more than just the market participants that you're alleging?
So, Your Honor, first, I would suggest that CC is already in the PSNS market as defined. I think the question that we need to look at here is how serious a competitive threat within that market does it pose to Facebook? And because of that, this is the reason for the commission's sort of insistence on the factor that it's not merely this niche foothold that CC has, but it's its ability, its demonstrated ability already to branch beyond that into the general the general services.
How was that demonstrated? It hasn't done it.
So it's true that CC itself has not actively deployed many of those general features, though it is poised to do so. However, I would suggest to the court that CC has already demonstrated its ability in the record to attract users that are not looking to CC for its specific healthcare-oriented capabilities, but are instead there to use it for its privacy protection as a general social networking service. And we can
Do you have any data on that?
I don't have a number of specific users, Your Honor. The data, the information in the record is anecdotal only. Although
Does
we
it
also
mention names? I mean, how do we know that anyone fits that category?
We don't have specific names, Your Honor. Based on the information in the record, what we have is anecdotal evidence, both that some users, and I apologize to the court, I don't have a more specific figure, have come to Facebook, but also that CC has demonstrated the ability to use its flexible base code to at least create features that could bring it beyond that healthcare-oriented audience.
From the record, I wonder whether you are also going to make, you have limited time right now, an argument about cross-elasticity.
Well, so Your Honor, I think cross-elasticity is significant, at the very least, to the market definition. And it's part of that reason that we include CC in the same fundamental PSNS market that we include with Facebook.
What's the evidence on cross-elasticity? It looked to me like there was really hardly anything.
Well, again, CC is in a nascent stage of development, Your Honor. But I think it's precisely because it's in that nascent stage, and that we still see, even in that nascent stage, some individuals coming to what is truly a niche palliative care healthcare market. That market has limited appeal on its own. That targeting has limited appeal on its own beyond that community. The fact that anyone is coming to CC in a market that we know is increasingly driven by the demand for privacy, something that Facebook has failed at in the past, is evidence, significant evidence that at this stage, CC has already demonstrated the significant capacity to break out beyond its market that it has already.
But counsel, yeah. CC, oh, forgive me, Your Honor, you go first.
No, go on.
Just briefly, you're describing CC, as a product that is used by patients, right, to connect with others similarly located and so forth. Why? How is that in our PSNS market, but LinkedIn, which allows people, to establish professional connections, is not?
Yes,
draw that line.
Pardon the interruption. Thank you, Your Honor. Yes. So LinkedIn, when we looked at LinkedIn, and I would suggest that defense counsel would probably agree with this as well. LinkedIn is a purely or close to purely professional services as one can get. CC does not fit that description. When we look at the original purpose for which CC was constructed, yes, it does have this capability to enable secure communications between healthcare providers and their patients. However, the original intent of CC was to enable patients to connect with one another, send updates to their family members, send updates to their loved ones, and include them in their community of care. Now,
last question. Quick question. What about what importance, if any, are you attaching to the burden upon CC? Why should CC be obliged to decline a lucrative offer? And please go ahead to answer my last minute question.
Yes, thank you, Your Honor. It's not that CC should be forced to decline a lucrative offer. What we're trying to point
surely that's exactly what you're doing. You're saying that CC is a nascent competitor. It's very small, but it might break out. Now you're looking and squeezing the facts or squeezing the evidence in order to make CC sound like a big competitor or a big potential. I repeat, aren't really what you're saying, and isn't it maybe the simpler line to say Facebook can't make acquisitions, Facebook has to grow internally?
I don't think so, Your Honor. Pardon me, Your Honor. Was that the court's question? I don't believe that's the case, Your Honor. I think that the factors that the commission has laid out sufficiently cabin the test in a way that limits it to acquisitions such as this, which are, we believe, facially anti-competitive. But it still allows for acquisitions in the context of mid-sized firms which don't possess the dominant market share that Facebook does. Because of this, it does not.
Wait a minute, that's addressing other firms acquiring CC, right? Not Facebook.
Or other firms acquire it, acquisitions sort of nascent competitors writ large, Your Honor. If there's a concern that this acquisition might set a precedent that categorically prohibits those nascent competitor mergers, we believe our test is cabined in such a way that that will not happen. We still believe that the investors who invest in these startups provide a significant competitive check. And we don't want to preclude using acquisition as an exit strategy for those investors. But I don't believe our test does that. It only does it in a narrow set of circumstances where we have a dominant player like Facebook with a proven track record of demolishing their competition through acquisition, where we have a competitor here with a high potential for growth and the demonstrated capacity to expand beyond its core base. And I see that my time has expired. If the court would indulge me for just a minute to finish this point.
Yes, please.
Thank you, Your Honor. The anti-competitive harms are not merely increasing concentration in an already concentrated market, which this easily does, but it also distorts the incentives of investors to cater to the whims of Facebook and not to consumers when we continually allow Facebook to gobble up these nascent firms. And finally, and perhaps most egregiously, it erects significant barriers to entry based on the direct and indirect network effects caused in the personal social networking services market by these acquisitions. Facebook, at best, has created a problem that it now wishes to solve by prohibiting advertisers from double dipping and then touting the effects of indirect network effects. For those reasons, Your Honor, the Commission would urge the court to grant the Commission's requested injunctive relief and prevent this merger. I will now turn it over to my co-counsel to address API. Thank you, Your Honor.
Thank you, Mr. Brown. Thank you.
Mr. Chief Justice, Your Honors, good afternoon and may it please the court. As Masonia looks to draft its own antitrust and competition law, the Commission believes that it is important that it sanction this conduct by Facebook in denying its API access to CC. We have two arguments for this. First, we believe that Masonia should adopt the essential facilities doctrine as it is applied under European Union competition law and as it has been proposed within the United States.
What's your authority for saying that it is part of European competition law?
Yes, Your Honor, I understand that it has not necessarily been adopted per se, but you can make out the tenets of a doctrine. And I think Bronner is probably the clearest case for that with the three requirements for.
But surely Bronner is a case where someone asked for a free lunch and didn't get it, and the court articulated reasons why he shouldn't get it. Are you saying that if someone turns up with those three reasons, he should get it?
Yes, Your Honor. We believe that those factors in Bronner do articulate, and we also believe that there's support in European Commission guidance. In a 2009 European Commission guidance document, the Commission provided three requirements for refusal to supply in this context. The first was that the product or service is required for effective competition in the downstream market. The second is that refusal to supply eliminates that competition. The third is that harms consumers as a result. I would also, Your Honor, to your
counsel.
Yes.
We were just hearing from your colleague arguing about the likely anti-competitive effects of an acquisition of CC because CC had so much promise. CC has gotten there without access to the API. How do we square that fact with what you're saying in terms of the importance of access to the API?
Yes, Your Honor, there certainly is tension here, and we recognize that. We think there's an important line that can be drawn, which is that within the tech market, these dominant platforms serve as a bottleneck. So CC was an incredibly promising nascent competitor in this market. However, once Facebook denied its API access, and once Facebook prevented ad sharing, prevented double dipping, to use the language of Lorraine Journal, once it took those actions, CC internally made the calculation that it could not grow itself, that it had to accept the buyout, which, as the Commission has asserted, led to anti-competitive effects on the terms that Facebook proposed. So in other words, we believe that CC was a promising competitor, but once it ran into this bottleneck that is inherent in the structure of the tech market, it couldn't surpass Facebook's refusal to provide it API access and denial of
It
access.
was sort of maximized in terms of where it could go without access to the API. That's the claim.
Yes, Your Honor. It was certainly growing quickly, but as CC itself believed, it was capped because of those strong network effects within the tech market.
Thank you.
Yes, Your Honor. Your Honor, back to your original question, I also think the Microsoft case from the European Commission and from the Court of First Instance is very important in establishing an essential facilities doctrine and a refusal to supply case under EU law. I also think, however, that the policy reasons that undergird it can be viewed within the US antitrust context. So we see several cases that scholars today point to as the beginnings of an essential facilities doctrine. While the US Supreme Court hasn't recognized it, I think we can see the same logic at work in St. Louis Terminal Railroad Association, in Ottertail, and in Aspen Skiing. In all of those cases, you had something about the market, whether it be the bluffs along the Mississippi in St. Louis, the nature of the Rocky Mountains in Aspen, or the utility monopoly in Ottertail, that prevented competitors from competing effectively. And the commission asserts that the structure of the tech market is similar in that way, that these bottlenecks that occur because of the network effects that are inherent here are so ingrained that they almost—
Counselor.
Yes.
Counselor, you are asking us to adopt the European standard. Do you think you lose if Aspen Skiing is the rule on duty to deal?
No, Your Honor, I don't. And the reason why is that we believe that the logic behind Aspen Skiing would condemn the arrangement here. So I'll move into my second part now about US antitrust law. Within Aspen Skiing and within—
Just before you leave Europe, if that was your intention, would you agree with me that there is no judgment of the European Court that endorses the proposition that essential facilities exists as a doctrine in European law? And I think there's no European Commission decision that says that essential facilities are part of the doctrine, part of the principles of European competition law.
Yes, Your Honor. I am not aware of a case that explicitly adopts a standard under that label, but I think you can look at the holdings in Microsoft and you can look at the justification in Bronner aligned with the scholarly commentary on those rationales and the guidance of the European Commission and withdraw these principles. So we're arguing that these principles that I've outlined here should constitute an essential facilities doctrine, even if it hasn't been adopted as such.
In those EU cases, was the allegation that, the premise that the firm in question was dominant in its market?
Yes, Your Honor. Certainly in Microsoft, that was the case.
Yeah. So that depends then upon our deciding, based on your colleague's prior argument, that so Facebook is dominant is dominant under EU standards or our monopoly under US standards, correct?
Yes, Your Honor. I agree with that.
I don't remember your colleague arguing the abuse of dominance, or rather, pardon me, the dominance issue, but I think we can extrapolate it then.
Yes, Your Honor. And I would argue, I believe my colleague did argue that Facebook enjoys monopoly power in this market. And I would argue that as
Yes.
the dominant standard is traditionally understood to be lower, that if the monopoly standard is satisfied, so would the—
All right, so returning to Aspen Skiing for just a moment now,
Yes, Your Honor.
under US law, the court is quite clear, I think, in saying that they're aware of no case in which they've ever said there's an essential facilities doctrine. And they didn't hold there was in that case. And so I don't know how you can come at us with these three prior cases, which are displaced, overtaken by Aspen, and Aspen's very demanding.
So, Your Honor, my response to that would be that we acknowledge that there is no essential facilities doctrine as such in the United States. We think that you can see the doctrinal roots of it in those three earlier cases in Ottertail and the Rain Journal and in St. Louis Terminal Railroad Association. And there are several scholars in the US today, notable scholars in the antitrust community, that advocate that we should be building upon that. And so that's where the US understanding of essential facilities, our argument is that we should build upon those cases and listen to advocates like the House Committee on the Judiciary in its report in 2020, which advocated for an essential facilities doctrine.
Well, yes, because it was advocating that the law be changed to incorporate that.
Yes.
Right. The implication is obviously that present law doesn't provide for it.
Yes, Your Honor, and we don't dispute that, and we would note that Masonia is not bound by current U.S. law.
Yeah, of course. All right. So you're just saying, even though the United States has not adopted this doctrine, the European Union has not adopted it. They've all looked at it closely and not adopted it. We should adopt it in Masonia.
Aren't you better going for a doctrine of superdominance, as has been flirted with in various cases? The notion that certain enterprises are so phenomenally large that they are subject to, I'm speaking of European law, exceptional burdens of competition law compliance.
Yes, Your Honor,
Yes.
we think that those would be appropriate to be adopted in Masonia as well. But we believe that even if that super dominance position weren't found, that this conduct would still be liable. I do want to return to Aspen-Skeen, though, because I think even without adopting the essential facilities doctrine, the logic that the court relied on in Aspen-Skeen and that the Trinco court revealed in discussing Aspen-Skeen support liability for Facebook here. So the Aspen-Skeen case, the court was really concerned with the sacrifice of immediate profits because that revealed an anti-competitive intent. In other words, the sacrifice short-term economic benefit reveals that they expected to recoup that through an anti-competitive effect down the line.
And what did they give up here? Their whatever tiny revenue CC produced for them by sharing the APIs?
So, Your Honor, yes.
A revenue that would probably be made up in a day for Facebook.
Within the facts, what they tell us are that it was API access in exchange for keeping CC's users within Facebook's user base. We think it's important to focus on the voluntary aspect of this. Trinco, which obviously was no friend of the essential facilities doctrine, held that the most important part of Aspen-Skeen was that the dealings were voluntary and thus presumably profitable. So in this case, yes, Your Honor.
No, there weren't any dealings, right? It never got off the ground, right? And in Aspen-Skeen, the companies had been working together, on the tickets for the lifts for a long time. Doesn't that essentially end your argument under Aspen-Skeen, the absence of a course of dealing?
So if we were in a U.S. court, Your Honor, I think it may. But we want to argue, and we believe that the logic of Aspen-Skeen is still present and that the course of dealing should be extended to a voluntary agreement in this case. So in this case, there was a voluntary agreement where Facebook thought that this arrangement was profitable. And that's what Trinco says, voluntary and thus presumably profitable.
It sounds like a policy that would deter a large company from entering into any kind of joint venture with a small one that it might someday want to acquire.
So, Your Honor, we propose
better to acquire it now rather than go and enter into a joint venture.
So, Your Honor, we share those concerns, the commission does, and that's why we propose a burden shifting framework. Essentially, if a firm in a dominant position wants to walk away from a voluntary arrangement, this suggests some anti-competitive motive, and the firm can rebut that by providing some form of pro-competitive justification. So if Facebook here can show that it was profitable to walk away from this arrangement, which it had previously thought was in its interest, then the court should not sanction it with liability. The issue is nothing in the facts show that any material evidence has changed. Instead, Facebook had an arrangement that it thought would be profitable, and it decided to forego those profits because it thought that anti-competitively erecting barriers to advancement for CC and then acquiring it would be a more profitable course.
Suppose that they
surely, well, we're saying the same thing, I suspect. The line you're taking must make it extremely difficult, maybe impossible, for Facebook to be able to discontinue a course of dealing with another competitor, with anyone. I mean, don't you need some limiting principles
So again, Your Honor, this is where we bring in that burden shifting framework. And I think the court, as it gains experience in applying this, I think it does adhere to the sacrifice of profits logic in Aspen, Skeen, and Trinco. As the court applies this, I think it'll gain better understanding at when market conditions change and when it is profitable to terminate these dealings. In other words, if there's a profitable reason to terminate the dealing, there should not be any antitrust or competition law liability, and the commission agrees with that.
Counselor,
Go ahead.
Your colleague was talking to us about the privacy differentiation that CC was engaged in. That's part of how it was establishing its own network effects and succeeding in growth. Can Facebook not, in the service of privacy, cut off access to a company to its own APIs? Like what if Facebook views a company as, getting a lot of information about consumers, using it in a bad way, right? They might lose some profits, but they're vindicating another consumer interest.
So, Your Honor, I see that my time has expired. Do you mind if I can answer your question here?
Please proceed, Counselor.
I think this, again, can be justified by pro-competitive benefits or by a profit. If Facebook chooses to terminate that API access in order to protect consumer privacy because it recognizes that privacy is an important consumer interest, that's not an anti-competitive, that's not an irrational decision, but for an anti-competitive effect later. In other words, they're making a defensible decision that they could easily raise to rebut that argument.
All right, thank you, counsel.
Thank you, Your Honors.
We'll hear from the defendants.
Mr. Chief Justice, Your Honors, may it please the court. My name is Jessica Schmitz, and along with my co-counsel, Andrew Krokstrom, we represent the defendant Facebook in the present action. I will begin by addressing Facebook's acquisition of CC, and my co-counselor will follow by addressing the API concern. We would concur with the commission that the court should look to American law today in assessing this acquisition. However, Facebook's acquisition of CC is not anti-competitive and is not illegal under Section 7 of the Clayton Act. Rather, it occasions significant efficiencies for consumers and is thereby welfare enhancing. For consumers, it increases quality on both CC and Facebook platforms, as well as occasions more choice for them in the market.
Counselor?
Yes, Your Honor.
Forgive my interruption. The attorneys on the other side said that they would need to show by a preponderance of the evidence that in the absence of the merger with Facebook, CC would go on and succeed. Do you agree with that test? Is that the right test?
I would agree with that test. I think it does account for, in a nascent competitor acquisition, there are issues of speculativeness. So they would need to show that there is a preponderance of the evidence that CC would be able to continue and become a non-de minimis competitor in this market.
Thank you.
So you just said that the merger would provide the benefits of quality and choice. How can you eliminate one firm in the market and call it an increase in choice?
It is an increase in choice for the consumers of CC who may have avoided using the platform. So something particular about social media platforms is that they work with network effects. So having the people who you are close to or would like to communicate with is important to wanting to be on that platform. CC becoming part of Facebook gives CC access to all of those network effects of Facebook, which are much larger currently and much faster. There is no evidence in the record that CC was going to be able to grow beyond the healthcare market. So those who may have wanted to have access to some of CC's features wouldn't have joined CC because they didn't need the healthcare aspects, but now would because it is broader under Facebook's platform.
So wait a minute. So it's not that CC's present users would now, by becoming part of the Facebook user base, have some advantage, but rather the other way around, that the Facebook user base would get the benefit of this?
It is both. So the quality of for CC users would also increase. But for Facebook users, it would be an increase in the privacy benefits. So they would then.
Oh, that's only if the privacy benefit of this tiny acquisition is then incorporated throughout the enormous Facebook universe, correct?
Absolutely.
Well, what reason is there to think that'll happen?
Yes, Your Honor, there is evidence in the record that Facebook at first saw this privacy platform that CC had created and tried to create it for itself, realized that it was going to take too long or too many resources, and realized it is more efficient to purchase it than to create it for itself. So
sorry, can I just, it's on the minds of everyone, including the press and antitrust commentators and naturally the three judges today, and that is that Facebook has a pattern, and it's not the only tech giant that has this pattern, but allegedly it has this tendency or pattern of swallowing the weasels, the mice, the dormice, the rats, the small creatures which are scuttling around, dwarfed by the Facebook elephant, lion, insert your vast animal. And I think it's quite commonly stated that there is an antitrust question as to whether an enterprise like Facebook, which is so huge, ought to be constrained, not just in a single, what's happening in this particular case, what are the pro and anti-competitive benefits, but more generally, issue of principle. Is an enterprise so vast as Facebook, so large, that special constraints should be made when it makes a relatively small acquisition? I'd like you to address that concern, which is widely expressed.
Yes, Your Honor. Where we would address this is that often those considerations of, we will call it per se bigness, is bad. Don't consider often the special characters of this market. So network effects work in both directions. A user of Facebook stays on Facebook because their grandmother or their next door neighbor is there. If it is a lot of strangers, they would leave. And also users leave when they are unhappy with the platform. We even see this in the record. There's evidence of Facebook users fleeing after the whistleblower incident. It is not Facebook.
But isn't it also true that flight was simultaneously shown as an increase in CC's subscribership, suggesting that they are indeed present competitors?
Yes, Your Honor, it does show that. And it actually shows also why Facebook found it so important to incorporate the privacy features of CC. They realized, as is no secret, Facebook has been known to have some privacy issues. So to meet user demand, privacy first centric of this market today, they needed to bring that on board and quickly for its users, or keep losing those users. So it is anyone who alleges that they would get rid of CC, it's substantially irrational for Facebook to do that. They are bringing them on board to adopt this technology and thereby enhance.
Counselor?
Yes.
Is it your position then that the only way that Facebook can improve its privacy is by acquiring CC?
It is not my position that it's the only way, but it is that it is the most efficient way, thereby not allowing for perchance. So if it costs more to create it versus buy it, that is occasioning dead weight loss that goes to the consumers directly.
I think they did try, did they not?
They did, and they realized it would be too expensive and too time consuming. Yes.
And is there any reason to think CC is the only way to buy it?
We don't have any evidence in the record to suggest that. However, CC has a proven track record with their privacy data and is also end-to-end encryption already created and HIPAA compliant, which is, we have no evidence in the record to suggest Facebook may have been able to get that elsewhere.
Thank you.
Counselor,
Yes.
if CC is distinguishing itself in part because of privacy, why wouldn't we worry about the diminution in the competition over privacy from this transaction?
The reason we would not worry is because even though it is distinguishing itself in privacy, does not mean it's the only one that can create privacy settings in its application. We've even seen recently Apple and other companies creating these quite quickly to meet user demand. It is not.
It sounds like you're saying Facebook's the only one that cannot.
Well, I think Facebook perhaps is the one who thought about their consumers and the efficiencies first. They thought about buying it instead of creating it, perhaps to get it into the market more quickly for its users.
But yes, we understand that, and the intra-company chat rather tends to confirm that. I mean, crudely put, we have a huge war chest. This little company may go somewhere. It's only 2 billion. Let's do it. Now, you haven't really answered my concern about, or the antitrust world's concern, that very large high-tech entities, there's only a small number of them, are systematically acquiring promising new entrants, and that maybe they should be subject to some constraints. You might say super constraints for super dominant players.
So we would argue first that Facebook is not a super dominant player in this market. They do have large.
What is their market share?
The market share is 44%.
Of what?
Of the PSNS market, including all the platforms excepting LinkedIn. And this is using.
So you're saying that Twitter is a competitor of Facebook?
Yes, we are. We are saying that
social networking, Twitter? I mean,
Yes.
It's basically a messaging service, isn't it?
it does have
Billboard?
features. Yes, Your Honor, it does have features of messaging, but it also has all of the features of enhancing personal connections, a one-to-many output, and it allows for these growth in your personal network, which are some of the elements the FTC looked to in their Facebook complaint against 2021. But to use their elements, Twitter is part of that market of personal social networking.
Counselor, from the MCC's perspective, under American antitrust law, doesn't Microsoft lessen what they need to show vis-a-vis the acquisition in terms of CC's likelihood of becoming a serious competitor to Facebook, right? Doesn't it just have to be reasonably capable of reaching that level of competition with Facebook?
That is what Microsoft said, yes. And I think in this instance, we don't even meet that lower standard because at the time they were acquired, we have in the record that CC was depleted of funds. They had created some infrastructure to be able to grow, but had taken no concrete steps to show that growth path.
So the record has a number of statements within the company about CC being a competitor. I'm not sure I'm aware of anything about, or I can't find anyway, anything about Facebook having tried to increase their privacy and failed rather than just simply saying it would take too long.
I believe it was in an email, an engineer said that they'd looked into it, but it was.
Oh, I see here. We tried building the CC clone.
Yes.
But that's all. Okay.
But I want to follow up on the Chief Justice's question. We do have an email from the chief executive, which is not painting this as a privacy-driven acquisition. Mm-hmm. So I respect your point that there's an engineer who said it, but doesn't it matter more what the chief executive said?
It does, but we may not have access to everything they've said. Often communications are also outside of that. And I would say that what the chief executive has said goes to intent. And the Supreme Court has said since Chicago Board of Trade that intent is not outcome determinative. It is the effect of the acquisition that is what matters. And I think if we think about that, a CEO could have said the same thing he did in an email, but never put it down on paper. The outcomes could be different. Intent is a hard level to look to.
Yes, it's too bad. Pardon me. Good for you. We don't have juries here.
Well,
these kinds of documents can be very persuasive.
Yes. Although some of these documents perhaps show Facebook's not so kind light, their vigorous competition, it is truly the effects of this acquisition that matter, and those are pro-competitive. So we discussed the quality of Facebook improving by incorporation of the privacy, but it is also that this allowing these type of acquisitions to continue promotes investment in general. So many tech startups need investors to grow and become competitors in the market and to have for consumers to have access to those innovations. But investors want to get a return on their money, and often that is done by acquisition. That is one of the few ways in the tech market to have a return on that. So
yes, we understand, and you're making articulately and elegantly the classical arguments to permit a large company to make an acquisition. But where I am, at least, and I think my brethren are maybe similarly concerned, wondering about where you stand on the bigger proposition, the doctrinal suggestion that an enterprise as huge as Facebook, which swallows small enterprises and then sometimes successfully, sometimes not, that's a pattern which leads to the reinforcement of Facebook's and other high-tech companies' extraordinary grip upon the market. And that for that reason, it should be, as a matter of principle, as a matter of doctrine, viewed skeptically, hostilely, or whatever.
So, Your Honor, I believe the first concern with that is looking just to the bigness of the company and not necessarily perhaps the features of the market. So often in this market, it is the companies perhaps need to be larger or more dominant because it is these network effects that are so valuable to consumers. If they are not big and having so many people, it may not be as valuable of a platform. So that would be one point. The second would be that we don't believe—
Counselor, sorry.
Yes.
We'll make your second point, then I have a follow-up on the first.
Absolutely. The second point would be that it is not that every nascent competitor acquisition should be permitted to move forward, that there may be times perhaps the court could look to whether it is a unique feature they're acquiring that's exceedingly difficult to replicate, or if the target company has maintained a durable foothold in the market or has a concrete path to growth. These are perhaps elements the court could look to in the future to determine nascent competitor acquisitions that are anti-competitive versus not, or pro-competitive, excuse me.
Counselor, I thought I heard you say a moment ago that one of the ways in which this merger would be beneficial is that it would add to the network effects for Facebook. But aren't network effects a kind of barrier to entry for competition later? And shouldn't we be very worried about building up the barriers to entry if it's competition that we want to see?
Yes, it is possible that if network effects used in a certain way could be barriers to entry. However, we do have evidence, even from CC itself entering the market, that network effects are not necessary. When CC was first growing, they had 60% annual growth rate year over year. And this is because although they didn't have network effects, they found a way to enter the market in a unique way. So it is not impossible to enter this market without those. And I believe the other response to that would be that network effects work in both directions as well. As I believe I said earlier, if users if they leave the platform, those network effects also work against the company.
So you're, see, I have this, that that CC carved out a small niche. Within that niche, there might be network effects, right? That would give it some insulation, but that merging it into a much larger body, which already has enormous network effects, barriers to entry, as my colleague said, would actually be better for competition for competition, because now Facebook would be an even more, have an even larger barrier around it, right? By virtue of this acquisition. I know time is up, but I'd like to have your answer.
Absolutely, Your Honor. So it is, we would argue that it is not just holding network effects that keeps a company dominant, but how they use them. And if it is Facebook, if Facebook has this acquisition and uses them incorrectly, users would leave the market. So it doesn't inhibit the competition or the choice of users for them to have more network effects. However, and it also, there's still, because this type of acquisition promotes more investment and innovation, more companies will enter the market as well.
All right, so let me just sure I've got that. So if Facebook provides poor service, those barriers you're saying will be overcome, people will leave and join some other firm, of which there'll be one less after this merger. And what other firm is there?
Right now, there is Snapchat, there's Twitter, Instagram, many other platforms.
Okay, the ones that were arguably in the same market.
Yes, Your Honor.
Okay, all right, thank you.
Thank you. I will, for the foregoing reasons, we ask the commission to permit this acquisition to move forward, and I will turn it over to my co-counsel.
Thank you.
Mr. Chief Justice, Your Honors, and may it please the court. Facebook should not face liability for preventing a competitor from using its proprietary data. Extending a duty to deal in this particular instance would put Masonia well beyond the global duty to deal in the global antitrust system. To be clear, Facebook would face no liability in this instance in the United States, nor do we believe they would face liability in the European Union.
Why not?
Because we do not believe it meets the test, as the court kind of discussed a little bit. My opposing counsel brought up the case of Microsoft, and we're happy to argue on the ground of the European Commission's case against Microsoft and the Sun Microsystems case. In that case, what the commission said was that, you had
in the Sun case, there was no prior course of dealing. Sun made a request to Microsoft, which Microsoft did not act upon. Here, you're extending that, it seems to me. No?
We do not believe that there was a course of dealing here, Your Honor. And if the court would indulge me for 1 second to circle back.
There was no course of dealing between Microsoft and Sun with respect to the technology underlying the Microsoft 2001 Windows Server software. There was no such course of dealing.
Correct. But what the commission said there was they found a duty to deal there in a very limited set of circumstances. One was the company doing the refusal deals in a dominant position. Two, that refusal had to relate to a product or service indispensable to the exercise of an activity on a neighboring market. I think a key point to hit on there is first, indispensability, and second, on a neighboring market. Here, we don't believe there is a neighboring market. As opposing counsel said, they conceded that CC is a competitor in this market. They said, as currently constituted, CC was a competitive threat to Facebook. And so and then second, on the indispensability point, we do not believe that access to Facebook's APIs is indispensable for success in this market. You can look into, so one, CC itself proves that these are not indispensable. CC had 60% year-over-year growth. Second, no other competitor has access to Facebook APIs. Snapchat does not have access to Facebook APIs. Twitter does not have access to APIs, and neither does Reddit. And I think that was key in the overall offer that happened here. So,
Counselor, I thought it was part of the record here that Facebook saw CC as a threat, that they turned off access to, they declined to allow access through the API, that CC suffered as a result. And with that diminished valuation, Facebook came in and bought the company. How is this not like standard oil stuff, right? You weaken your competitor and then you go in and you take them out with an acquisition.
And before you answer, let me chime in from the European point of view. I'd suggest to you that this is a bit like commercial solvents in Zoya. And there was a vertical merger planned between a supplier and a quite small company called Ichi, and the merger fell through. And to punish the merger target, the supplier decided to, at least according to the decision, which was upheld by the court, the supplier decided to interrupt the course of dealing and thereby threaten with extinction its former customer. Isn't that the best analogy for what your client has been doing?
Respectfully, we would disagree slightly in that these APIs were never shared, and there was never a course of dealing in this instance. So Facebook offered CC to be access to its APIs. Within that offer was the specific right to refuse if Facebook ever viewed CC to be a competitor. CC then developed different features that had a broader applicability outside of the healthcare market and had a broader applicability to the social network market. And you can see how CC was poised to change due to internal discussions within CC and their board. So their CEO wanted to stay more aimed at the healthcare market, and their board sought to expand. So CC agreed with Facebook in that CC had a broader applicability to become a competitor. And again, Facebook does not open its APIs to competitors. Facebook opens its APIs to build on its platform. And I think it's important for a court not to institute a duty to deal and allow another company to free ride off of its infrastructure. One of the things the court said in Trinco that why we need to be wary of a course of dealing is incentives to innovate. Companies need to create infrastructure that is uniquely suited to their users. If we do not allow them to profit off that infrastructure, the next Facebook is less likely to create infrastructure uniquely suited to their users.
Mr. Krokstrom, what justifies, in your account of things, Facebook's decision to prevent advertisers from placing ads on both services? That sounds like the Rain Journal to me.
We acknowledge there are some similarities between this conduct and Lorraine Journal. However, I would like to point out a few differences. First, in Lorraine Journal's market share was 99%. Here we have demonstrated Facebook's market share is 46% market share. Facebook does not have the ability to provide the anti-competitive effects that Lorraine Journal is able to have. Second, the conduct in Lorraine Journal would have totally destroyed the radio company WEOL. Here, this conduct would not have totally destroyed CC, as you can see as evidenced by CC's year-over-year growth. CC's ads and their company in general still had standalone value absent CC's APIs, or absent Facebook APIs. And finally, that conduct in Lorraine Journal had no benefit but to destroy competition. And I think there is a benefit in the court allowing Facebook to profit because their investors need returns for that vast infrastructure they were able to create. And second,
that's a rather broad justification. If we accept that, it'll apply in every case.
Well, and to my colleague's point, and counsel, I want you to speak to this, but that isn't why Facebook did it. Doesn't it matter that Facebook did this specifically because CC was a competitor?
Going back to my co-counsel's point about intent, so I think the reasons for why they did it are important, but again, we have to look at anti-competitive effects. And I think that Facebook, through its smaller market share, does not have the ability to anti-competitively raise prices in the way that these other companies did. And to the extent that any of these prices would be raised on the advertiser side of the market, the plaintiffs have not bought any data on that side of the market. There's no evidence that Facebook has any pricing power in the advertising side of the market. If advertisers did not want to deal with Facebook or did not like this course of dealing, they were free to advertise on Google, on Amazon, on anywhere else.
But not on CC.
Correct.
Peculiar. What else have you got, Mr. Krokstrom?
So I think we would like to first talk about aspen skiing as opposing counsel brought up. I think what the court faced in aspen skiing was a monopolist who refused to sell a product that had already sold at market rates because it wished to diminish a product of consumer demand. And here, I think opposing counsel acknowledged that this doesn't neatly fit the elements met out in aspen skiing. So I won't walk the court through them, but I also want to point out just the difference in market power and structure of the market here. There are not limitations on supply in the same way. So this is not, as in terminal railroad, this is not a bridge over St. Louis, or this is not for Mountain View.
Surely, we agree that it's not a bridge, but sadly, I mean, for you, your company is one of the largest on earth. It's an iconic business enterprise. And I suggest to you that in my days at the bar, when one was confronted with having an unpopular and enormous client, it was wise not to pretend that the client was Mother Teresa. I just wonder how plausible it is for you to point accurately to distinctions which neglect the dimensions of the elephant.
I am not here to tell you that Facebook is the size of a bridge. What I'm here to tell you is that there are part of the reasons why Facebook is so big is because it offers products, it offers services to consumers that consumers demand. Facebook is not the first company that attempted to graph everybody's social network, but what they are is the company who continues to do it the best. So I think so because of that, they were able to grow. And then as my co-counsel started saying about these network effects lead these companies to growth. So I think it's hard to hold Facebook's success against it when part of the reason why is it successful is because other people are on the market. So the bigger it is, the more successful that it becomes to be. And that does not foreclose on other companies or other people being able to come into the market. Because you can see the records replete with companies who have came in after Facebook was made and after Facebook reached this massive market share. Snapchat still came in, was able to be successful. Twitter still came in and was able to be successful. And Reddit still came and was still able to grow exponentially after Facebook came into the market.
Well, we know as a matter of public record that Facebook did a better job than MySpace, which it displaced. But we also know that it then acquired WhatsApp and Instagram and countless much smaller companies, some of which were no doubt similarly potential entrants or nascent participants in the personal social networking field. So that I can't make much of your point that these other firms that came in afterward have survived. Maybe it just tells us that they're not really in the same market at all, that they're providing a different service. Certainly LinkedIn is, and it looks to me like Twitter may be as well.
We believe them to be in the same market because we believe consumers to use them rather interchangeably. And I'm glad the court brought up Instagram. I think Instagram is oftentimes used as an example of Facebook's anti-competitive conduct. But if you look at what Instagram was at the time of acquisition, it was broadly an app with filters over photos. What Facebook was able to do was able to leverage all of its resources, leverage its research and development, and create and move these products and give it greater access to everybody else. The exact access to scale that Facebook was able to provide is what enabled Instagram to grow in the way that it did.
And are you saying that's what we're looking at here for CC?
Yeah, I believe that CC provides some innovative privacy features, and I think it is important for Facebook users to be able to have access to those features on Facebook. Facebook attempted to acquire, if the court would
Counselor,
CC would have had that if they hadn't been denied the APIs.
They would not have had access in the same way because we don't believe the APIs they would not have had access to CC on Facebook. So now they do. They would have been two separate apps, and CC would have had Facebook data, and they would have had a little more data growth, but you would not have been able to use CC on Facebook in the same way. They would not have the same product integration that they
Counselor,
would.
what is the evidence in the record for what your colleague was telling us earlier is your position together that absent the acquisition of CC by Facebook, Facebook can't improve privacy? Among other things, the acquisition would take out a competitor that was distinguishing itself on privacy. It would also give Facebook access to a host of the most sensitive information in the world. That is medical information, right, about people's health and how they're doing. That's got to be the top of our privacy concern. What's the evidence that the acquisition is necessary for Facebook to improve its privacy?
First, in regards to the point about access to information, we believe, I'm rather confident CC is end-to-end encrypted. So I don't believe Facebook would have access to that data. That's part of the the great things that CC provides is this HIPAA compliant protection. And then
That's not going to be expanded to the whole user base from Facebook?
that encryption element would prevent Facebook from being able to see within that data. That is part of the use case of CC, Your Honor.
I see. So would this acquisition enable Facebook to become HIPAA compliant for everything it does that's outside of the CC database?
I'm unsure. I don't think the record has enough data for us to really say to what specific purpose Facebook would be able to use and how.
Well, I mean, we're over time here, but you've confused me on a point I thought I had understood. I thought that this acquisition was going to bring benefits, or so we were being told, to Facebook users that are not available to them now, specifically with regard to privacy. But now I'm not so sure if that's what you're saying, or whether these are going to be kept as two separate entities, much like Instagram is a separate entity, or whether somebody who is a Facebook user now would, after the acquisition, have some additional privacy.
Your Honor, I do not believe the record really indicates what Facebook's intended use of this is, but I think what the record is clear is that CC, by joining Facebook, will have access to a vast greater amount of resources and greater amount of data, and Facebook, and we'll be able to now leverage Facebook's social graph to be able to get access to a vast more amount of consumers.
So it will not disappear into the user base of Facebook.
Again, I do not believe the record truly indicates what Facebook's specific intent is. I can't.
Okay, and I think we have it. That's as good as we can get on this record. Mr. Bailiff, are we over time as I think we are? All right, well then I think it's time to hear from the plaintiff's rebuttal here.
Thank you, Your Honor. I'd like to make several points on rebuttal. First, I would like to respond to the test that our friends and colleagues on defense counsel have proposed for the court to distinguish between pro and anti-competitive conduct. Specifically, defense counsel cites one particular feature as indicative of a merger being anti-competitive, and that is when a nascent competitor or an entrant to the market has innovated in a way that is exceedingly difficult to replicate. Now, Facebook itself has admitted that it has not created the ability, nor has any other firm, to replicate CC's privacy concerns. I would argue, Your Honors, that the defense counsel's own factor cuts against its argument. Now, second, I want to respond to defense counsel's position that the acquisition will increase consumer choice and consumer quality. In fact, the commission believes it will do exactly the opposite. And the reason is because what drives innovation in this market is competitive pressure, in particular from these nascent competitors. Once CC is merged into Facebook, what incentive does Facebook have to maintain the robustness of these privacy protections? In particular, when defense counsel is unsure as to whether or not it will scale those up to offer them to a higher user base. In fact, why would Facebook expend the massive resources it may likely require to maintain the robustness of those protections when it no longer faces competitive pressure from the outside? Third, I want to respond to defense counsel's argument regarding network effects. The network effects, as the court suggested, do create significant barriers to entry. However, the commission grants defense counsel's point that given CC's initial success, it is not theoretically impossible that those network effects can be chipped away at by CC taking users away from Facebook. The problem now is that Facebook has policed those barriers by continuing to acquire these nascent firms. The theoretical capability for a firm like CC to draw users away from Facebook and diminish those network effects has absolutely no significance if the court is to permit Facebook to continue to devour these nascent competitors. Sorry. Now, third, Your Honor, I would simply remind the court of the problem with exit strategies. It is true that we don't want to diminish that capability entirely and relieve that competitive pressure. However, we also don't want to end up in a situation where Facebook continues to take in so many of these firms that innovators start to cater to the whims of Facebook and not to consumers who demand better products of their own accord. Finally, Your Honor, I would simply like to respond to—
But I think there's evidence around the world that that's exactly what happens now, that many startups are started up in the very hope of selling to one of the incumbent giant firms.
Oh, that's absolutely true, Your Honor. And we would not propose a test that precludes that possibility. We would only say that in the context of significant market dominance and Facebook's repeated pattern of doing this causes the potential to distort those investments away from consumer welfare and towards CC. So with that, Your Honor, we truly thank the court for its time and attention. We respectfully request that it grant the injunctive relief requested by the commission. Thank you, Your Honors.
Thank you, counsel. The court will take a brief recess in order to deliberate and return shortly. Okay, well, thank you for the arguments and the extraordinary effort that obviously went into preparing, and that got you to the finals in this competition with, I'm sure, a number of fine teams I know from fine schools. So our first duty is to keep you in suspense while we announce the winners of the teams that were submitted the best brief, and the oralist who most distinguished him or herself in the prior rounds. So the award for the best brief goes to the Harvard Law School team. I take some satisfaction in that. Since George Mason could not win, I just as soon have Harvard win. The best oralist has been singled out, and she is Kristin Barkemeyer from the Washington and Lee team. So congratulations to her as well. Considering the number of oralists here, that's quite a distinction, I must say. So we turn now to the argument just heard, and I will tell you our verdict, and we will then each, in the tradition of the English bench, each render a decision. So the winning team here are the counsel for Facebook. So congratulations to counsel for Facebook. Did a terrific job. Actually, everyone did a terrific job, which makes this a little more vexing than it might otherwise be. On the other hand, we really don't want a very one-sided argument either. So it's satisfying to have a close case, and this was a close case. But in this, we are unanimous. And so for some comments on the proceedings, we'll turn first to Judge Phillips.
Thank you, Chief. Thank you, Your Honor. I want to begin by echoing what Judge Ginsburg said, which is that this was close, because everyone delivered what I thought were terrific arguments. I thought you had a very live bench, and that was very distracting. All of you were interrupted, very within seconds, really, of opening. And I thought each of you did a great job of kind of coming back to the arguments that you wanted to make. So let me start with that, and that it was very close. The thing I think, for me, I'll pick on a couple of anecdotes just to highlight. Jessica, you had this moment where I was asking you about the standard, what level of lessening of competition you had to show. And you saw that it was a friendly. You saw what Andrew Guinan, I hope I'm getting your name right, Andrew, had said. He had given you preponderance of the evidence. You pocketed it and you walked on, right? You were very much tracking like, oh, that was a good thing for me, even though I had teed it up as that's what your co-counsel's position is. So I thought that was good. Andy, I loved what you did on Lorraine Journal.
Now this would be, which Andrew are we here?
I'm sorry, Andrew.
Oh, yes, Andy.
Okay.
Sorry, yeah.
I was playing with the Andy and the Andrew. It was a bad case for you. You said it was a bad case. You distinguished it and again moved on. And I thought that those were just great, like pivot / taking things in stride, which is really critical in oral argument because it's hard. It's hard to make your points when you're trying to answer the particulars that the judges are going after. At the risk, I don't want to monopolize time, so I think we should probably go to Judge Forrester next.
All right. Well, I found this enormous fun. A little bit of personal background. I was a litigator for 30 years, and I argued cases like cases about refusal to deal, and I argued Microsoft catastrophically unsuccessfully before the General Court. As I've said frequently, I held the world record for the world's most unsuccessful antitrust lawyer, in that no lawyer since Hammurabi had seen his client fined more than $3 billion with a B. So that's a distinguished record. I very, very much honor the practice of looking at the facts. You can't, so, and then, having been a Queen's Counsel for umpteen years, I was appointed by the Brits to be a judge in the General Court. And one of our jobs is to hear appeals against acts of the European institutions, and antitrust, regulation, access to documents, state aid, bunch of different subjects. Any act of the European institutions is potentially susceptible of judicial review before the General Court. The quality of the advocacy that we had today, with judges harassing you every 30 seconds, is significantly better, I'm sorry to say, than the advocacy that was routine in the General Court, because it is by no means universal that lawyers, even well-known litigators, are comfortable dealing with questions that go to the fundamentals. Some of them are extraordinarily good, and some of them just aren't. And I know from having seen good and bad how good today's session was. I thought that the Facebook team was more rooted in the facts and ducked and weaved a bit more successfully than the prosecution, than the agency. And so my vote would go, and did go, to Andy and Jessica. But as we've all three of us said, in these things, the distinctions are very fine. Making it to the final is a very powerful indication of great talent for the future. And I hope that you'll go back proud of your getting the silver medal.
Well, I'll pick it up there and ask, first of all, has everybody here taken a class in antitrust? So you weren't starting at ground zero. We've had some very good advocates in past years who, it turns out, learned everything they knew in preparation for the moot court, which is dicey, but they did it. So the single most important thing to me was, and actually both of my colleagues have mentioned it, was the emphasis on the facts. For the commission, there was a lot of what we talked about, or what you presented, I should say, was doctrinal. And so to some extent it has to be, but what one wants to do is, as quickly as possible, get back to how that doctrine applies to the facts in the particular case. And whereas the argument for the company, both of you really emphasize the facts in the record. My guess is that everyone was intimately familiar with all of the facts in the record, but counsel for the company really alluded to them and invoked them and quoted them pretty much all the time, as much as possible. Now, that strategically is a very good move, I think, because the facts here could be construed as being really devastating to the company. So you need to bring out the facts that could be devastating and show why they're not. And I think that was a good choice of how to approach the matter. Counsel for the commission, given this this opportunity to invoke law from either, well, principally the US or the EU, either jurisdiction, I don't think always chose the stricter jurisdiction under which you could say, well, if it doesn't pass muster here, clearly it does not in the other. Now, maybe it wasn't that clear, but there's an argument to be made there, I think, to made more explicit, perhaps. On very small matters, I would urge you all not to say we would argue. You are arguing. Either do it or don't. It's not a counterfactual subjunctive, which you may or may be doing something under other circumstances. I am asked frequently in the moot court context by the competitors whether oral argument matters in appellate cases. And I think the facts are, well, let me see, I'll just tell you how the judges proceed, at least in the DC circuit. And I've sat by designation with the 11th Circuit for the last 5 years as well. The judges come in completely prepared in both places I've found. It's not true everywhere. There are judges, there is a federal circuit where I understand the judges come in and hear the argument before they read briefs or a bench memorandum prepared by staff attorneys. But the judges typically in these two jurisdictions come in completely prepared and with some questions they want resolved, some ambiguities, maybe about the record, but often about the argument you're making, looking at the implications of it and saying, well, to themselves, that's just too broad. I mean, that's going to invite God knows what in its wake. And so if we can get that narrowed, if we can get a concession from, not talking with each other necessarily, but if I can get a concession from counsel to force that back, either it will make it possible to agree, or alternatively, it will make it a slam dunk to disagree. So each judge comes in typically with some questions in his or her own mind about that. Now, how often is that material to the outcome? I would say it resolves the way in which the panel is going to proceed to resolve the case, a particular ground on which they will rest, what they will avoid, what they will narrow, in a substantial minority of the cases. Does it change the outcome from the tentative outcome before the judges came in? Probably in 5 to 10% of the cases. Mm-hmm. But that's not to say that changing the way in which the court approaches it or affecting the way in which it approaches it is not important. It's terribly important for your clients. So the bottom line is this may be the case in which the outcome depends upon it, or the sweep of the decision that will affect future concerns of your client or others. And so therefore it's material. It's important, even if it's not going to necessarily change the outcome. And then the judges go back immediately after conference, as we did here, and confer. And try to, if we don't right away, then try to converge on points on which we can agree. And try to make it, at least in my court, as narrow as possible, in both the courts I've served, make it as narrow as possible, just because as a prudential concern. But even in non-constitutional cases, in order to conserve the potential for future rulings. That said, I'm open to taking questions if you have some. This is an opportunity for you. Probably won't come again. If you can tap into Judge Forrester's immense experience and store of anecdotes, you'll be very fortunate. We went an hour last year.
Could I just add a thought?
Here we go.
Often you see judges see counsel who've got a list of things they want to get through, and they regard questions from the bench as being a bit of a nuisance because they have 5 points and they have 6 pages, and I don't really want to talk about market definition. But if the judge wants to talk about it, that means that the judge is revealing to you what's on the judge's mind. And that's a great privilege. The most terrifying court before which I've ever appeared was the House of Lords. And there, 5 gentlemen, white, grey, in suits, and counsel in wigs and all the trimmings, argued for 3-4 days about whatever the subject was. Because you are there on appeal, it is clear that there is an issue to be debated. If your case was a waste of time, you wouldn't have been accorded this privilege, this opportunity to argue before high-level judges. And so you may guess what is the issue in the case. May I have a glass of water? Sure. You may guess what you think is the important thing, but the indications from the judges are the precious divulgation of what it is that's on their mind. So embrace what's on their mind, embrace the question, and give it far more attention, if you can, than you had planned to. And that is a real difficulty if you are one of those lawyers who has prepared a nice script but hasn't internalized it and was planning to gabble through it from the start to the finish. Anyway, that's questions are very valuable. And in the Anglo-American tradition, they are perfectly polite. But in the French tradition, some arguments are really like a kind of insult because you're interrupting, super, thanks. You're interrupting a learned avocat in full flow, and his decorated rococo speech will be interrupted as if you were stubbing a cigarette into his souffle. It's much, but I have said judges should be rude to counsel, and counsel should be rude to judges to insist on answers to important questions. So,
and it's the French tradition. It's the French tradition that applies in the courts of the European Union. The Brits and the Irish being outliers, and now the British outcast as well. So, by self-outcast. But to pick up on one of Judge Forrester's early points there, we hear oral argument in about 50% of the cases in the DC Circuit. That's very high among the circuits. It's probably 40, 35%, something like that in the 11th Circuit, and lower. The larger circuits with so many more cases, the 9th Circuit, for example, in the US, a very small percentage of cases get argued. On the other hand, in the 2nd Circuit, every case gets 10 minutes. And of course, you're allowed to go on longer if the court's interested, but they do accord order. Or they may have changed that, but their tradition has been that every case gets us a hearing of some sort. Reading an argument is a devastating miscue. It's just even looking to your notes for a cue is a bit of a distraction. When I was clerking in the Supreme Court, there was an argument one time with counsel from the New York State Attorney General's office in an equal protection challenge to some Medicare rule. And after droning on for about 10 or 15 minutes and having lost the attention of the court entirely, then Associate Justice Rehnquist said, "Counsel, are you familiar with Rule 44 of this court?" Well, of course she would not be. And so she said, "No, sir, no, Mr. Justice." And he said, "Well, it provides that arguments that are read are not favored." Well, of course, now it was even worse. I mean, she couldn't go on without reading, and she couldn't read. It was just a nightmare. She flubbed around until it was over, put out of her misery. On the other hand, well, it's in the same vein, really. It is said in our US Supreme Court that if you haven't been interrupted in 2 minutes, the court's not interested. And with 9 justices, that's a fair reading. I think in our court, it might be 4 minutes. We have only 3 tormentors waiting to get at you. So you really don't want to read, you don't want to drone, you don't want to discourage in any way the questions that are so valuable, as Judge Forrester just reminded us all. Any questions?
We don't bite.
Okay, I'll bite. Judge Phillips?
Oh, I was simply going to say, I was not aware going into this that you guys are all from the University of Missouri Law School. So
You are?
really,
Not that either.
congrats to
James are from
Mizzou.
Missouri. Well, where's Tom? Did he come over? He's here. Oh, Tom, congratulations. That's great. Tom Lambert, Ian is a professor on the faculty there, and he's accompanied the teams most years. I think he didn't come one year, a COVID year maybe, where we were virtual. So whatever, no, that couldn't have been because he would be right there with you. Must have been the year before that. But anyway, he's been sending terrific teams, and now he's got the ultimate. Taking gold and silver. That's fantastic. How did you know that? I didn't know this. I
asked.
Where does it say? No, where does it say that it was University of Missouri?
It's not in our record. I pinged whoever Global Antitrust Institute is. So whoever that is.
They told you. Okay. Yes. Well, I should have been that curious. Well, this is great. Well, congratulations to you all and to Tom.
Really, you all did a terrific job.
Tom, do not take this as a cue that you've peaked and you're going to retire from this enterprise. On the contrary, there's always third place to capture as well. That's based on a score, not on arguments. Okay, well, it's been a pleasure, and a pleasure that's been increased now by knowing that you're all here courtesy of Tom Lambert.
How many teams were there?
12, I think, or is it 12 or 14? I think it was 12. Yeah. I think there were could have been 13 or 14, but that doesn't work. It has to go from 12 to 16. We decided to go virtual fairly late in the fall, so that some teams from overseas that might have participated had it been virtual, had they known it would be virtual, didn't have the opportunity. But in past years, we've had teams from, the Jindal University in India won one of the, took the gold one year, several years ago. We've had teams from Northeast Asia and Belgium, and not sure where else, but a couple of other places as well.
Well, congrats to all of you.
Yes,
it was terrific.
Congratulations. It was good fun for all of us as well, I think. And yeah, I'm sorry to say it's 2:48. We've really enjoyed ourselves, so we just kept on.
And
all right, take care, everyone. Congrats to all the contestants. You all did really well.
And Noah, as Ian knows, this is like pinball. If you win, you get to play again. So I hope you all will come back next year.
I haven't participated in Moot Court since I was in law school. So there you go. This was great. Really, all the contestants. Congratulations.
I hadn't been in a courtroom except traffic court in Chicago until I became a judge. So, and we couldn't be a trial judge because I didn't know how to do that. All right. Thank you. Bye. Congratulations.
Good afternoon, everybody.
Very much.